Assalamualaikum warahmatullahi wabarakatuh. I am Wardina Mardhiyyah binti Arof with number matrix 1212746. Today, I will present individual written assignment for subject commercial law LAC 4443. My case review is titled Law Kieng vs AXA Affin General Insurance Berhad and another suit, whereas this case is from 1974. Okay, now here is a quick summary on what I will present for today. I separated them into three parts, where for the first part is about summary of the fact and issue for the case. For this part, I will talk about introduction, fact, and legal issue for this case. Moving on for the next one is decision made for this case. And the last one, I will talk about the application of law for this case. Now, let's talk about case review introduction. So, case review is a case study that allows researchers to apply variety tools for a single issue. The goal is to determine judge activities in deciding the case. Action also filed as a breach, whereas plaintiff seeking compensation for the incident that occurred. Moving on to the fact of the case. Plaintiff collapsed while gardening and cut his eyes. The plaintiff lost money, suffered anguish, and couldn't work. In surgery, Dr. Chen said that plaintiff's right eye injury caused lens loss, globe perforation, and Birch's hemorrhage. The plaintiff claimed AXA Affin General Berhad and Pacific Insurance Berhad failed, disregard, or refused to pay him under their individual policies that violating their terms and conditions. The plaintiff requested 500,000 ringgit from AXA and 250,000 ringgit from Pacific. The defendants argued the injury wasn't a covered accident. The defendant claimed he caused the plaintiff loss by holding pruning scissors without safety equipment. This is legal issue for a few problems that arise for the fact of the case. The first one is whether the plaintiff has standing to sue the insurance company for an unintentional fault while gardening. And the second one is whether the defendant, which is AXA Affin General Insurance and other suit, is violating the policy terms and conditions. Here is the second part of my presentation for today. This is the decision addressed by the judge during the judgment day. So the first one, the plaintiff had the onus of proof when the defendant demanded it. The plaintiff must establish on a balance of probabilities that his injuries or loss was due to the risk of insured by the policy. So although it may be foolhardy for the plaintiff to climb the rambutan tree while holding the scissors, it could not be classified as a reckless or dangerous activity such as winter sports, rock climbing, mountaineering, parachuting, or big game hunting under the policy's exclusion 15 clause. And the second one is, no sane person would pierce his own eyes with pruning scissors. The plaintiff's injuries was a covered risk under the policy. No evidence suggests he pricked or pierced his right eyes. We now arrive to the last part of my presentation for today, which is application of law. So the first law is Arbitration Act 2005, Section 10. It is said that arbitration agreement and substantive claim before court. So in the case review, a court that hears a case involving an arbitration agreement must stay the case if a party requests it before taking any other step, unless the agreement is void, inoperative, or unenforceable. The next act used is Insurance Act 1996, Section 150, Number 1, Column A, whereas it is said that before a contract of insurance is entered, a proposer shall disclose to the licensed insurer a matter that A. He knows to be relevant to the decision of the licensed insurer on whether to accept the risk or not, and the risk and terms to be applied. So in the case review, it is said that the defendant said that insurance contract were fair. The policy was based on form responses. The defendants claimed that plaintiff failed to disclose material facts that were known to him but not to them. So due to the plaintiff's failure to disclose material facts, such as his full insurance policy, the defendants could lawfully repudiate all policy liabilities. Plaintiff breached contract, said the defendants. Then, this case also referred to Insurance Act Section 150, Number 2, Column A, B, C, and D, whereas it is said that provide that the duty of disclosures does not require a disclosure of a matter that A. diminish the risk to be licensed insurer, B. is a common knowledge, C. The licensed insurer knows or in the ordinary course of his business ought to know, or D. In respect of which the licensed insurer has waived any requirement of disclosure. So in the case review, the defendant did not argue that the plaintiff's failure to disclose all insurance policies would affect the risk, premium, terms, or condition of the AXA and Pacific policies. No defendant's witnesses testified this. There was no evidence that the non-disclosure of the plaintiff's insurance policy would affect the risk, premium, term, and condition of these two policies. And the last one is Insurance Act Section 150, number 3. That said, provide that where a proposal fails to answer or give an incomplete or irrelevant answer to a question contained in the proposal form or asked by the licensed insurer. So in the case, the AXA proposal form was dated June 11, 2008 and the policy was issued 17 June 2008. Similarly, the Pacific Insurance proposal form and policy were both dated May 12, 2009. So the defendant didn't clarify the plaintiff proposal answer. That's all for my presentation for today. Thank you for your attention, and if you have any question, you can find me at Wardina92@gmail.com. Thank you and have a good day. Assalamualaikum warahmatullahi wabarakatuh.